Article 148 of the Family Code of the Philippines states that in cases of cohabitation not falling under the preceding article, only the properties acquired by both of the parties through their actual joint contribution of money, property, or industry shall be owned by them in common in proportion to their respective contributions. In the absence of proof to the contrary, their contributions and corresponding shares are presumed to be equal. The same rule and presumption shall apply to joint deposits of money and evidences of credit. If one of the parties is validly married to another, his or her share in the co-ownership shall accrue to the absolute community or conjugal partnership existing in such valid marriage. If the party who acted in bad faith is not validly married to another, his or her share shall be forfeited in the manner provided in the last paragraph of the preceding article. The foregoing rules on forfeiture shall likewise apply even if both parties are in bad faith. The property regime under Article 148. So Article 148 applies to a relationship not within the ambit of Article 147. In short, if any one of the requirements under Article 147 is absent, Article 148 will apply. However, the parties may be deemed to be co-owners of a property acquired during the cohabitation only upon proof that each made an actual contribution to its acquisition. Without proof of actual contribution, a co-ownership under Article 148 cannot arise. For example, in the case of Dolce Vida de Canada versus Backlot, GR number 221874, centers on a dispute over ownership of properties acquired by Sancho Canada during his common law relationship with Crescencia Backlot, while he was still legally married to Agripina Dolce-Vida de Canada. Sancho and Agripina were married in 1937 and had 6 children. In 1952, Sancho entered into a common law relationship with Crescencia, with whom he had 7 children. Sancho died in state in 1973, and Agripina, as administrator of his estate, filed a lawsuit in 1994 to recover ownership of properties she claimed were acquired by Sancho during his cohabitation with Crescencia. The case primarily dealt with the ownership of these properties, which were registered in Crescencia's name, and whether they could be considered part of the state for Sancho's legal heirs. The Court of Appeals ruled in favor of Crescencia's heirs, finding that Agripina failed to prove that Sancho had a joint contribution to the acquisition of the properties, particularly since the properties were in Crescencia's name and no evidence showed that they were jointly acquired. The ruling relied on Article 148 of the Family Code, which governs property relations between individuals who cohabit but are not married, requiring proof of actual joint contribution for co-ownership. The Philippine Supreme Court affirmed the Court of Appeals decision, highlighting that without proof of actual contribution, the properties could not be considered jointly owned. The court also noted that the cohabitation between Sancho and Crescencia was governed by Article 148 rather than the provision for valid marriages, because Sancho's first marriage to Agripina was still subsisting at the time of his cohabitation with Crescencia. So the relationships contemplated under Article 148 include the following. Number one, a man and a woman living together as husband and wife without benefit of marriage but are not capacitated to marry. Number two, an adulterous relationship even if it occurred prior to the effectivity of the family code. 3. A bigamous or polygamous marriage. 4. Incestuous void marriages under Article 37 and Article 38. 5. Void marriages by reason of public policy under Article 38. So the structure of the property regime, which is a limited co-ownership under Article 148, are as follows. 1. The salaries and wages are separately owned by the parties, and if any of the spouse is married, his or her salary is the property of the conjugal partnership gains of such legitimate marriage. 2. Property slowly acquired by funds of any of the parties belong to such party. 3. Only the properties acquired by both of the parties through their actual joint contribution of money, property, or industry shall be owned by them in common in proportion to their respective contributions. 4. The respective shares of the parties over properties owned in common are presumed to be equal. However, proofs may be shown to show that their contribution and respective shares are not equal. Without proof of actual contribution by both parties, there can be no presumption of co-ownership and equal sharing. 5. The rule and presumption mentioned above shall apply to joint deposits of money and evidences of credit. And 6. If one of the parties is validly married to another, his or her share in the co-ownership shall accrue to the absolute community or conjugal partnership existing in such valid marriage. If the party who acted in bad faith is not validly married to another, his or her share shall be forfeited in the manner provided in the last paragraph of Article 147. The foregoing rules on forfeitures shall likewise apply even if both parties are in bad faith. So in Juaniza versus Jose, where a woman who was living in a bigamous relationship with a married man was sought to be held liable for an accident involving a vehicle driven by the bigamous husband and where the vehicle was registered under the name of the said husband. The Supreme Court ruled that the woman cannot be held liable as a co-owner of the vehicle because the vehicle must be considered the conjugal property of the bigamous husband and his legitimate spouse. Under Article 148, only the properties acquired by both of the parties through their actual joint contribution of money, property, or industry shall be owned by them in common in proportion to their contributions. It must be stressed that actual contribution is required by this provision. The law likewise states the second paragraph of the Article 148 provides for rules on forfeitures of all shares shall likewise apply even if both parties are in bad faith. Thus, if a spouse and his bigamous wife, who happens to be relative by consanguinity within the first civil degree of the former, jointly contribute to their co-ownership while living together, with the husband contributing his salary and the bigamous cousin wife likewise contributing her salary, the co-ownership shall be liquidated as follows. The share of the spouse who is obviously in bad faith shall accrue to the absolute community or conjugal partnership of his existing valid marriage, while the share of the bigamous cousin wife who is also in bad faith shall be forfeited in favor of their common children. In case of default of or waiver of any or all the common children or their descendants, each vacant share shall belong to the respective surviving descendants, and in the absence of descendants, such share shall belong to the innocent party.